Mr. Weissman, I have a couple of questions for you, but and then I'll give you your comments. We will be looking, and you may not know the answer to these questions, but we will hope to hear from you about the answers soon. One is, do you know when you will be filing your application, Edison's application, for review of the 2012 songs costs based on the GRC order? That's one question. And second will be on the steam generator replacement cost application.
The application with respect to the 2012 costs, I believe the GRC decision directs Edison to file that application on January 30th, if memory serves, so we intend to meet that date.
Okay.
With respect to the SGRP application, we don't have a fixed date, but we're projecting March.
March. All right, thank you. Okay, and do you have any further comments about the our preliminary thinking on the phasing and timing, recognizing that you have made statements in your, and I offer this to all the parties, we don't need to hear what you've already put in your papers, we've read them. So I'm asking you to respond today to our thinking about the phasing.
Thank you, Your Honor. I wonder if I might clarify the scope of Phase 3, which I jotted down as involving the review of the SGRP repair replacement options and the SGRP costs, but I'm not confident I wrote it down correctly. I thought I heard at another point Your Honor may have made a comment about future operations being considered an LTPP rather than this proceeding, so I wasn't sure that I fully grasped your intention in that regard.
In Phase 3, it's our expectation that when Edison files its application, as it's been directed to in the prior proceeding, approving the project, preliminarily approving it, that that will begin. That will be what we consider in Phase 3, and that will also include any various options for repair if you're going that way, if you're planning on decommissioning. We're expecting Edison to come forward with some thoughts at that point about where they're going. So we will be looking at what happened in between 2004 and 2012,
Yes.
and then what's happened since then. Were there avoided costs? Were there extra costs? Have you recovered costs from other sources? That would be the Phase 3 on steam generator replacement.
And it would include an evaluation of any proposal or plan with respect to the future operation of the plant.
We would be looking at expenses that you wish to incur in 2012 and 2013 relative to the steam generators and this replacement project. If you're trying to ask the question, are we going to consider in this OII whether to shut down songs? Is that your question? And if so, the answer is I believe not. That would not be part of the scope. Is that your thinking, Commissioner?
I guess if Edison proposes to spend a bunch of money to repair or replace the steam generators, other parties could say that's not cost effective.
And we might find it unreasonable, but that's different than saying
Right.
we're ordering you to shut down. We're just not going to give you the money for it.
Yeah.
Okay.
Well said.
Okay.
For that clarification.
Before I move on, let me cut the one other primary party on the hot seat. San Diego, do you have any thoughts on the phasing? Is that, or that we've discussed?
No, I don't. I'm not going to repeat what I've stated in my...
Right. Thank you.
Your Honor,
All right.
Pardon me, I wasn't...
Mr. Weissman, you had one more thought?
Yes, I'm sorry. I simply wanted to comment on the schedule,
Okay.
if I might, which we don't object to. I would say that I believe that the premise of Phase 3, as you've articulated, is that certain issues or facts will have been clarified in sufficient time for the Commission intelligently to address them on the schedule that we contemplated, and some of those, the timing of the development of some of those facts is not entirely within our control. And
Understood.
so that may warrant the Commission reconsidering the schedule at a later date.
Okay. It is our intention to scope one phase at a time. Although they may not be completely sequential. There may be some overlap to get a next phase going. Division of Ratepayer Advocates, Ms. Tedisco.
Thank you, Your Honor. As I mentioned earlier, DRA's primary concern is the immediate removal of the songs cost from rates, and we think that's a legal issue. If the Commission would set a briefing date that could bring that to the Commission's consideration as soon as possible, I think it's a matter of some urgency. As to the phasing approach and a schedule for future phases, we did not submit a pre-hearing conference statement, but our thinking was that instead of actually setting a schedule now for future phases, if the Commission would set a further pre-hearing conference to be held the soonest of either date we get information from the NRC about whether either one of these units is going to restart, or a decision from Edison that it's not going to attempt to restart them, then we might all be in a better position to estimate what sort of timeline we need for testimony and hearings. My concern about setting any dates for hearings, well, especially with the dates we have set now that Edison and SDG&E are going to submit testimony tomorrow, since we haven't seen it yet, I'm not sure what it's going to say or how comprehensive DRA's responses could be in our testimony on January 29th.
My next question is the 29th enough time?
I don't know. I don't have any idea what Edison is going to provide, so
Okay.
I can't say.
Let me just come back to Mr. Warden for a minute. On your monthly reports that you're starting to send in, will that include a component about NRC action?
Yes, Your Honor. We will have an update of regulatory developments or operational issues at the site, in addition to the monthly accounting of O&M costs incurred and so forth.
And those reports are being filed in CERT, or are they just being submitted to Energy Division?
My recollection is that it was required they be served on
that's what I
parties to
thought.
the
Okay.
case.
All right, so they'll also be on the website.
Yes, Your Honor.
All right, thank you. Mr. Friedman?
Thank you, Your Honor. Matt Friedman on behalf of TURN. I'd like to echo Ms. Tedisco's comments. I think it is important for the Commission to move expeditiously on the legal process and briefing related to the removal of costs from rates pursuant to Section 455.5A. And we'd like to suggest that that legal briefing process could move concurrently with Phase 1, which I understand would be devoted specifically to enumerating the costs that could be covered by any order subject to Phase 2. In terms of the timing, I noticed that there's a significant gap in time between the submission of rebuttal testimony and the hearing dates that you have suggested. A February 13 date for rebuttal testimony, and I think I heard April hearings.
Yes, that I anticipated that these dates might slip on the testimony.
And I would like to suggest that we cause those dates to slip just a little bit. I know from our perspective, we're going to be looking at Edison and San Diego's testimony, and we intend to provide some kind of submission to the Commission. So more than a couple of weeks would be very helpful, especially if hearings wouldn't be scheduled until April anyway. Or an opportunity to submit supplemental testimony if we discover other issues through the process of discovery data requests and so on.
Okay, do you have a suggested date for the reply testimony?
I guess off the top of my head, I might suggest mid-February with a rebuttal date sometime in early March to mid-March, and then hearings following that.
Okay, so perhaps February 15th? And then rebuttal March 8th. And then we could be looking, at that point, we might have a status conference if I see there's any problems going on, but otherwise then we can start to look at April as hearings. The goal of getting a decision out by early summer. Any objection to those dates? Does that sound, Mr. Weissman?
Would it be possible to consider something closer to the middle of March for the
Rebuttal?
Rebuttal, please.
The 15?
That would be ideal.
Okay. All right.
And I would like to object to the dates because those dates seem to be designed to get San Onofre back into operation ASAP and not really designed to support the investigation that the public's been led to believe the commission was conducting.
Okay. Let's see, Ms. Sheriff? Sheriff? Oh,
Your Honor,
Friedman?
I did have one other
Okay.
comment.
Sorry.
Point of confusion, perhaps. When you originally described Phase 3 devoted to the SGRP costs
Yes.
and reasonableness review,
Yes.
you identified 2014 as a timeline for that occurring. Did I mishear?
No, yes, we hope to be done with the first two phases, the review of 2012 and the review of rate base this year, and then move into to the steam generator replacement using the record we've developed. And hopefully by that time, that gives time for the regulatory and litigation process to unfold with Edison and its potential contributors to costs.
That makes sense to us. I hear Edison saying that they want to submit their application in March of this year, unless I misheard Mr. Weissman. And I don't know how that application would be able to take into account all of the factors that you've identified that should be considered in that process.
Well, there will be additional updates, and perhaps Mr. Weissman intends to submit some testimony in that phase that would provide additional information. Did you have a thought about that, Mr. Weissman?
Yes, the application that I alluded to would simply comply with the SGRP decision as we read it, which is to say we would submit testimony regarding the costs, and we anticipated a demonstration the cost would have come in under the cap. So it would not go into the other issues that might be pertinent in Phase 3.
In your initial application,
That's
it's going to be
correct.
responsive to the original decision in the 04 case.
Correct.
All right, and the scoping memo that's issued in that will likely expand that scope to pick up additional costs, future replacement or repair, cost effectiveness discussions, and so forth.
Understood.
So,
And I guess I would add, my final thought, Your Honor, is that Edison's proposal to divorce a consideration of reasonableness from the determination of whether costs came in under the cap, to me would be a huge mistake, and I hope the Commission wouldn't go that way. In other words, Edison is essentially proposing that the Commission simply look to see whether the total costs come in below $680 million, and that would essentially be the end of that process. And that a discussion of whether there were reasonableness or prudence concerns would come at some much later date. And from our perspective, it would be fundamentally unreasonable not to consider these issues together.
duly noted, and I think that we're in general agreement with that. Okay, Ms. Sheriff.
Thank you, Your Honor. Good morning, Commissioner Florio. Nora Sheriff for the Energy Producers and Users Coalition. EPUC joins with the other ratepayer representatives in urging legal briefing sooner rather than later or concurrently with the Phase 1 testimony. And EPUC would be fine with the dates that you've proposed, the February 15th reply testimony and March 15th reply testimony for Phase 1. Your suggested phasings for the remainder also seem reasonable to us.
Okay, thank you. Mr. Giesman?
Thank you, Your Honor. John Giesman on behalf of the Alliance for Nuclear Responsibility. I would chime in with DRA and TURN and the energy users as to the primary importance of addressing the legal aspects of taking the plant out of rates. I am somewhat confused by your distinction between Phase 1 and Phase 2 and left unclear as to whether you would be prepared to make a decision on taking the plant out of rate base prior to Phase 2. The plant is neither used nor useful today based on Mr. Craver's comments to investors in the summer it would appear that Unit 3 has been abandoned altogether. My client is strongly of the belief that the plant under Section 455.5 should be taken out of rates immediately, and I am not clear as to whether your phasing between Phase 1 and Phase 2 would defer that decision unduly or not.
Well, 455.5 does direct the commission to hold a hearing before removing anything from rate base. In order to do that, we have to have an evidentiary record which tells us which pieces of plant are no longer used and useful, and then make a decision about whether it's just and reasonable to remove it from rate base. One can't, our view is that there needs to be a record in order to do that. We're starting with the record of finding out in Phase 1 what exactly happened. What actions did Edison take? What costs did they incur as a result of the shutdown? What costs did they avoid? What pieces of the facility are not operating? What pieces are? And that gives us a basis to go into the rate-based discussion under 455.5 as to whether it's reasonable to take out, remove, or eliminate from the value of certain pieces of plant. So to just simply say, the plant's not operating, take a couple billion out, is not a responsible or an appropriate action. The purpose of this proceeding is to establish a very clear evidentiary record of what was done, what was spent, why, and what wasn't operating.
Your Honor, I certainly think that you should do that. What I'm not clear on is when you anticipate having developed the record and having had the briefing that would enable you to make a decision on whether the plant should come out of rates or not.
I think that our expectation is later this year.
Well, then I would indicate that the Alliance has a very strong concern as to the wisdom of deferring that decision for such a long time. Section 454.8, which does apply to new plants, makes very clear that the used and useful concept is intended to assure that ratepayers in a given year will not pay for the benefits received in other years. There is no way to rationalize what benefit the ratepayers have received from this plant in 2012, and from the sounds of it, no way to rationalize what benefit they may receive from 2013. And as a consequence, I think the Commission would be well advised to make as prompt a decision, supported by an evidentiary record, on whether the plant should come out of rates or not.
All right, thank you very much. Mr. Reed?
Yes, I've got a question and a comment. My question is, will the effect on natural gas prices from SONGS being down be part of the scope? And my comment is, nuclear power, the existence of nuclear power plants has been a major public issue in California since at least 1972. That's when I got here. Since the debate over Proposition 20, which established the California Coastal Commission. A recent poll has found that 65% of Californians are now opposed to nuclear power.
Okay, Mr. Reed, I'm gonna stop you here because we're not gonna be doing debates about the policy and the substance today. We're working on procedure here.
Right, this is my comment.
Okay.
I think it's time that the Commission took up the issue concerning decommissioning of these nuclear power plants. And I think the best place to do that is in this proceeding, as opposed to the long-term procurement proceedings, which is bogged down with many, many, many issues.
Okay, all right.
So
Thank you.
that's my
The only
comment.
excuse me, no. The only comment I would make is regarding the natural gas issues. There is an open proceeding, the TCAP, the Triennial Cost Allocation Proceeding, which I think is the one that's going to be handling the natural gas impact. I don't anticipate this coming into the scope of this proceeding at this point. So just on that note, and it was raised in some of the comments. I'd like to check in with some of the other parties. Where's my list of parties? go. How about,
This is yes.
yes. This is, now, Joan Walter?
Yes.
From the Energy Commission. Can you enlighten us as to your interest, the Commission's interest in this proceeding and what you expect your role to be?
Yes. Good morning, and thank you, Your Honor, and Commissioner Florio. My name is Joan Walter. I'm Nuclear Policy Advisor with the California Energy Commission. I'd like to thank the PUC for opening this proceeding and allowing us to provide comments today. We're here to listen to the parties' topics of interest, as well as provide support through the process as a collaborative agency with the PUC. And as indicated in the OII, the first phase will likely address cost implications for replacement power, but will also address service reliability issues in the near term. Last summer, the Energy Commission participated with the PUC and CalISO in summer contingency planning led by the Governor's Office. And in the ISO's local capacity technical analysis, there are a number of mitigation measures related to reliability issues, some of which may be dealt with in other forums, and some which may be dealt with in this forum. So depending on the proper forum to work through the planning issues over the next few years, the Energy Commission plans to work closely with our sister agencies, including the PUC. As these issues work their way through the scope of the OII, Energy Commission would like to offer some ways that we can work together collaboratively. As the state liaison officer to the Nuclear Regulatory Commission, the chair of the Energy Commission has been closely following the NRC proceedings regarding San Onofre. We would be happy to collaborate by sharing information with the PUC and about the NRC investigation. And then relative to replacement power for California, in the short to mid-term, we're interested in collaborating with the PUC as well. So in conclusion, we'd like to support the PUC through this process, and we look forward to working with them in the future.
All right, thank you very much. I'm going to check in with some of these the other parties here. Remember, I'm not looking for anything you've said in your submitted filings. I've read them all. What I'm looking for is comments about the scope and phasing that we have preliminarily outlined today. California Cogeneration Council, are you here? No. CQ? Yes, please identify yourself.
I'm Jamie Malden on behalf of the Coalition of California Utility Employees. We have proposed an additional issue to be included in the OII, and based on the phasing that was presented this morning, we think that that would best be included in phase 2.
Okay.
Thank you.
Clean Coalition, are you here?
Right here, Deanna Delphine-Polk.
I'm sorry, your name, please? Can you spell it?
D-Y-A-N-A. My last name is Polk, P-O-L-K. We have no objection to the scope or to the schedule at this time.
Thank you very much. Friends of the Earth? Are you here?
Yeah, I'm Larry Chassett, representing Friends of the Earth. Your Honor, you stated earlier that we're going to look at the alternatives to San Onofre in the LTPP proceeding, and I'd like to know when we might get an idea of how and when that will be considered. Perhaps Commissioner Florio can answer that. And then Dave Freeman also has some comments, but I'd like that question answered first. Thank you.
I think it's going to depend on how things evolve. If Edison were at some point to say we're no longer seeking to reopen Unit 3, I think it would then become an issue in the LTPP how to replace that power. If they come in here and say we want to spend X million dollars to refurbish and continue to operate Unit 2, then that expenditure and alternatives to it might be appropriate here. So I think it's going to depend somewhat on how the circumstances evolve. Short-term issues, as the Energy Commission referred to, may come up here. If Edison needs guidance about some action it wants to take in the near term to maintain reliability, we might take that up here. But question of replacing a unit that is no longer available is normally an LTPP issue. It's only if it becomes a disputed issue.